know I got the receipts, girl. You know I got the receipts. Hello, welcome back to another edition of the Sweet Pea Diaries. It's your girl Sweet Pea, and I'm back with another video. If you are a returning subscriber, welcome back to my channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like the video, share the video, but most importantly, be sure to subscribe to the channel. All right, guys, we're bringing in 2022 with a lawsuit update. Hey, Jerica James, Vanderveer, Baby Shay 81, Mamad Monica Reyna, Oakland Barbie, back to back. Yes, ma'am. Excuse me, we have an update with this lawsuit, and people have been DMing me. They've been sending me messages all day asking me, Sweet Pea, will you please do the update? Go over these court documents. Says there are updates. There's updates. We got new developments. Can you please go over it? So, of course, Susie Davis Jones, Shay Bay 30. Hey, you guys. So, of course, I have to do what my subscribers ask. But one thing I'm going to give a brief, just a brief public service announcement as people start to come in. We are 2 minutes into this broadcast, and I just want to give house rules. Now, when we discuss this lawsuit, now I'm going to tell you, my channel has been growing. I'm getting new subscribers. I'm doing different material. We are branching out into uncharted territory. We're doing true crime videos. We are still doing celebrity gossip, but we're going to be branching into specific shows. We have a roster that is coming up, so we are going to be branching out into specific shows. These lawsuit updates will be a specific show. We're going to have a new separate intro for these. We're going to have days dedicated to these updates. And this is going to be a whole dedicated show. When we do these lawsuit updates, I'm asking that everyone be respectful, that they be mindful that these lawsuits can go either way. Some days you're going to have an update where it's going to be favorable to the plaintiff. Sometimes you're going to have an update when it's not going to be favorable, and it's going to be favorable to the defendants. So we have to be respectful. We can't allow our biased opinions to get in the way. Hold on for 1 second. Yes, please keep it cute or you're going to go on mute. We have to be respectful. There's just going to be times where, it's not going to be favorable to who you like. So we just have to be mindful, and we want to be respectful of that. We're not in court with these people. We don't know these people. And so we can't get caught up into our personal opinions. Either way it goes, we're going to read the updates and we're going to give what it's giving. All right. So with that being said, we're going to jump right into it because we have a lot of material to cover. So basically, there's been an update in the lawsuit. It is still not the judge. I've been saying my personal opinion, and I know that we're dealing with COVID. I know that the courts are backed up, but we still have not heard from the judge. He has not made a decision. He has not ruled on the default judgment against Nicki Minaj. So the update that we have the attorneys. They are going back and forth. Judd Bernstein, who is on behalf of Nicki Minaj, he's been sending emails to Tyrone Blackburn. He's been sending emails stating he doesn't believe that Tyrone and company are being fair. They're not doing things according to the normal way of law, legal proceedings go. They're just not doing things correctly. So we're going back and forth in these emails, and we're going to take a look at that. Judd Bernstein, who is Nicki Minaj's attorney, they submitted these emails as evidence, as exhibits with their brief. Now, their brief is in direct response to this default judgment. They believe that the court should just throw it out. The court should not honor it. It should not be a default judgment issued against Miss Mirage. They do not believe that the court should hear it, should not entertain it, and they believe that Jennifer's lawsuit is frivolous. So they're saying this in their brief. So we're going to jump right into it. We're going to share my screen and we're going to read this. This is the brief from Nicki Minaj's attorney in direct response to this default judgment. So again, this is not the judge. This is not the court. No one is issuing an order. We still do not have an order from the judge. This is all from the defense. All right. So let's dive in. Hey, Miss Jordan, I'm about to dive in. Oh, that might not be the right song, honey. Trey Songz. He is being accused. That might not be the right song, but I'm about to dive in it. We're going to dive into these court documents. So let's get on and get the break it down. Right? So let's get into it. All right. So this is defendant Onika Tanya Miraz's memorandum of law in opposition to plaintiff's motion for entry of default judgment. Okay. And I'm going to give y'all the full screen so you can read along with me because we have about 100 documents to go through. This brief is extremely long. It is detailed. So we're going to try to go through it as quickly as we can. I'm going to read some of it. I'm going to paraphrase. I'm just going to jump in it and try to give you the tea. But I don't think that we're going to read every freaking paragraph because if that, we're going to be here all night. So the introduction. Plaintiff Jennifer Hough, her motion for a default judgment demonstrates that she is desperate to avoid litigating the case on the merits. So they're saying that Jennifer wants to hurry up and have a default judgment issued because she is desperate. She knows that her case is meritless. It is meritless. It does not stand on any merits. Her efforts to deny defendant Onika Tanya Miraj an opportunity to defend herself is understandable because the plaintiff's amended complaint is more than just frivolous on the law. It's false and at best reckless. The allegations that defendant Miraj engaged in criminal accusation and activities would be libelous, even against a public figure. But for the protections of the litigation privilege, they are beyond the pale. This case is nothing more than a bad faith attempt to extort the defendant through the judicial process. Plaintiff's current motion is, if possible, even more frivolous than her amended complaint. Her claim that the defendant made a strategic choice to delay this matter and avoid responding to the amended complaint cannot be reconciled with the indisputable facts of records which show that the plaintiff is the only party in the case who has sought to delay its resolution on the merits. Give me 1 second. Evan is showing out. He's doing what he does every time I get on live. Give me 1 moment. Sorry, guys. And again, I'm sharing the screen, so I am reading the documents. So forgive me if I cannot answer your comments. I can't see them because I'm reading. So I will check in with you, but just let me get through these documents. So the plaintiff is the only party in this case who has sought to delay its resolution on these merits. A, the plaintiff contends and defendant denies that the amended complaint was properly served on September 15th, 2021, and that a response to the amended complaint was due on October 6, 2021. B, on October 11th, 2021, the plaintiff took the highly unusual step of requesting a certificate of default from the clerk's office just 5 days after the purported deadline for responding to the amended complaint. On October 13th, 2021, just 2 days later, and only 7 days after the purported deadline for responding to the amended complaint, defendant's counsel informed plaintiff's counsel that he expected to file a notice of appearance the next day and requested only 18 days, which was until November 1st, to answer or move against the complaint. After plaintiff's counsel refused this request, defendant's counsel filed a notice of appearance the next day, and on October 14th, 2021, is when they did that. On the following day, October 15th, they filed a motion seeking leave to file a late pre-motion conference letter. So we know that Nicki had used her attorney to enter a notice of appearance instead of actually answering to the lawsuit. They also then that next day filed a motion seeking leave to file a late pre-motion conference letter. This is still not a response to the lawsuit. On October 19th, 2021, the clerk refused to enter a default against defendant Mirage, and the plaintiff filed a letter motion seeking an order directing the clerk to enter the default. And defendant's counsel responded to the motion. 2 days later, on October 22nd, the defendant's counsel offered to litigate the parties' motions simultaneously on an expedited schedule and further offered that if the court directed the clerk to enter a default, the briefing on defendant's motion will be deemed to be a fully briefed motion to vacate the default pursuant to Rule 55C. Plaintiff's counsel rejected this offer. So Tyrone and them over there have rejected every advance that the defendants have made. They want everything to go through court. They want everything to go through the legal, usual proceedings that things go through. If a defendant is late in answering to a lawsuit, they seek a default judgment. However, the defendants and her attorneys feel as though this should not be. They feel as though they should have backdoor conversations. They should be allowed to have email exchanges, and that they should somehow work together as, lawyers representing these plaintiff and defendant, and they should work together. They should work behind the scenes. Tyrone and them don't feel that way. They feel that everything should go through the court. Instead, the plaintiff's counsel waited another 3 days until October 25th to send a letter to the court seeking to further delay the case by asking that the plaintiff's motion be decided before the parties litigated the substantive issue of whether a default judgment should be entered against the defendant. The next day, October 26th, the court granted plaintiff's counsel request that the plaintiff's motion be decided first. Ruled on and decided first, and that the plaintiff's motion shall be ruled on in due course before the court rules on any presently pending or forthcoming motions. So the court did grant Jennifer the request that the motion be decided first and that it be ruled on before they answer to any forthcoming motion. So we are still currently waiting on this to be ruled on by the court. Plaintiff's counsel then waited more than a month until November 30th to switch course and consent to defendant's counsel October 22nd's proposal of simultaneous briefing, which defendant's counsel now opposed for the reasons set forth in his response to plaintiff's counsel request. Plaintiff's counsel legal arguments are no more credible. Her counsel have not cited a single case in which a default has been granted on facts similar to the facts here. Hence, they have resorted to selectively quoting judicial decisions and mischaracterizing their holdings. Statement of facts. The facts and documents relevant to a determination of this motion are set forth in or annexed to the Bernstein Declaration, the accompanying December 30th, 2021 declaration of the defendant, as well as documents which are publicly available. As demonstrated therein, the plaintiff's account of the facts has been a work in progress, as she has changed material parts of her story since she started telling it in media interviews and elsewhere. The amended complaint's factual allegations are either demonstratably false, internally inconsistent, illogical, or amount to nothing more than entire speculative and irrational references. So they're saying that Jennifer has been doing media interviews. She has been having her story in the media, and every time she's speaking, her story is inconsistent. It's illogical, and there is nothing to this case. It is speculative and irrational. So there's an example in Exhibit D where Bernstein has a chart comparing prior statements that Jennifer made in March 2021 in her interview with the Daily Beast. And he put that against the amended complaint and shows the differences in the material. So we will go over that as well. But he took the liberty to detail that in these paragraphs. In paragraph 93 of the amended complaint, it is alleged that the plaintiff's brother informed her that two people reached out to the family member stating there is an offer of $500,000 from defendant Mirage if the plaintiff wrote a letter recanting her rape claim against Petty. Yet in March 2021, the plaintiff told the Daily Beast that only one person, someone named Jamie, had reached out to their cousin and was offering her $50,000 if she merely spoke with a lawyer representing Petty. Now, I read that paragraph before I started this video, and I don't see what the discrepancy is here. If we're going to be really consistent with wording and we're going to make a person stick to every time they do an interview or they recant or talk about the story or talk about what has happened to them, they have to use the exact words. I don't know where they do that at. I mean, every time I do videos or anything or do any statements, sometimes my words are going to vary. So they're holding her to using every word for word. Her comments, they must be word for word all of the time. This statement means the same thing. It says that a family member says somebody reached out. They're saying that she said only somebody named Jamie and they offered $500,000. This is the same thing. I don't understand what the difference is, but they're saying there are differences. Paragraph 93 of the amended complaint also alleged that after this alleged call, the plaintiff hung up, distraught that defendant Mirages instructed her associates to contact her brother, and her brother would even relay such a message. But yet in March 2021, the plaintiff told the Daily Beast that Black, the person whom the plaintiff alleges to have been acting on behalf of the defendant, denied that defendant or Mr. Petty was offering her any money and that she was confused as to how all of this was happening around her. I still don't see what the issue is here. And I'm just citing what I see. Please do not hold it against me. I'm not trying to be biased, but I just don't see what the difference is here. She said that they did not offer her money directly. They're going through other people. They're using other people to offer money. So when she says that no one offered her money, that's her truth. No one's offering her money. People are going through people to directly and indirectly, which is what the lawsuit says is happening. She's being contacted directly and sometimes indirectly, being other people are being used. Paragraph 103 of the amended complaint alleges that when Black allegedly offered the plaintiff a $20,000 bribe, he even said that defendant Minaj would also send happy birthday videos to plaintiff's daughter for her birthday as a bonus. Yet in March 2021, the plaintiff told the Daily Beast that Black wanted defendant to appear at his daughter's 16th birthday party, and further that she believed that her brother had been in the middle of these supposed bribes threats because he and their cousin wanted defendant to do a walkthrough to promote at a club so that they could split the profit. Finally, we wish to draw the court's attention to paragraphs 6 through 8 of the defendant's declaration, in which she appropriately expressed her outrage at plaintiff's counsel for his appalling, baseless accusations that defendant is a member of a violent street gang and that she has been directing gang members to threaten the plaintiff on video, which she was streaming live on Instagram. Moreover, we ask that the court watch the 7-minute video which counsel has submitted to the court in support of these accusations. The declaration of Tyrone Blackburn, which was mailed to Chambers, they wanted the court to read that as well because it demonstrates how utterly unprofessional and outrageous these accusations are. To be clear, these accusations post-date the amended complaint, but counsel has nonetheless asserted them for no legitimate reason in documents which was filed with the court. Nonetheless, they are emblematic of plaintiff's and her counsel's bad faith efforts to tar defendant Minaj without any factual basis, and we believe should inform the court's assessment of their current motion. Now, argument, point 1. The governing law. So now they're citing laws and they're saying that when a party against whom a judgment for affirmative belief is sought has failed to plead or otherwise defend, and that failure is shown by an affidavit or otherwise, the clerk must enter the party's default. Now, there is a 2-step process for obtaining the entry of default judgment. First, the entry of a default, and second, the entry of a default judgment. While courts are entitled to enforce compliance with the time limits of the rules by various means, the extreme sanction of a default judgment must remain a weapon of last rather than first resort. So Nicki Minaj's attorney is saying that why would we just rush to a default judgment? Why would we, rather than, talk this out and allow time, why would we use this as the first recourse? This should remain a weapon of last resort rather than issuing it because they are late. Again, Tyrone Blackburn feels that if this is the law, this is what, should happen. The default judgment should be issued, but Bernstein sees otherwise. There is a strong preference for resolving disputes on the merits, and because a default judgment is the most severe sanction which the court may apply, the court has characterized a district court's discretion in proceeding under Rule 55 as circumscribed. Now, when doubt exists as to whether a default should be granted or vacated, the doubt should be resolved in favor of the defaulting party. So he's saying that the law generally sides with the defaulting party when there is doubt as to whether the default should be granted or vacated. They usually side with the defaulting party and they don't issue the default judgment. He cites various court cases where this is done. The court may also consider other relevant equitable factors, such as whether the entry of default would bring about a harsh or unfair result. These principles are particularly important, whereas here, the plaintiff is seeking a large money judgment. And then they cite other cases. Additionally, where substantial sums of money are at stake, this may tip the balance of equities in favor of vacating a default. So he's saying because there is large monies at stake here, this is even more reason why the default judgment should not just be immediately issued. And I said this before. Oh, excuse me. I said this before that the judge may not issue the default judgment because it is a lot of money involved, and rather just then saying, okay, you won by default, here's your money. Nicki Minaj's attorney is making point of that. Now, in deciding a motion of default judgment or to vacate a default judgment, the district court is to be guided principally by three factors: whether the default was willful, whether the defendant demonstrated the existence of meritorious defense, and whether and to what extent that vacating the default will cause the non-defaulting party prejudice. These same factors are considered on a motion to vacate a default judgment. However, although the factors examined in deciding whether to set aside a default or vacate a default judgment are the same, courts apply the factors more rigorously in the case of a default judgment because the concepts of finality and litigation repose are more deeply implicated in the latter action. This difference is reflected in the fact that Rule 55C is governed by a good cause standard. Point 2, the plaintiff's motion should be denied because she failed to comply with Local Rule 55.1. Now, Local Rule 55.1, which supplements Rule 55A, requires a party seeking an entry of default under Rule 55A to file an affidavit demonstrating that the pleading to which no response has been made was properly served. In this case, the plaintiff filed a request for a certificate of default pursuant to Local Rule 55.1 on October 11, 2021. However, counsel's supporting affidavit did not state that the amended complaint had been properly served. In fact, the Blackburn LR 55.1 affidavit did not mention service of the pleadings. I don't know why they would say that. I read these documents and I look at these statements, and in my mind, I'm like, these are bold-faced lies. They did state that there was service of this amended complaint. They even issued an affidavit showing Diaz's issuing of the complaint. They had him sign a declaration. They had him sign a statement stating that he served it. They had his paperwork where he turned into the process serving his job. I don't know what more they want from the process server and to show proof that this was delivered to Nicki Minaj. On October 19, 2021, the clerk denied plaintiff's application because it appears from the docket that the defendant has filed a notice of appearance. So that's what the court clerk, the reason that they did not actually grant the application, because they stated that it appeared that Nicki Minaj's lawyer had entered a notice of appearance to the court. So why would we grant a default judgment? They're typically usually an answer to what you plan to do with the lawsuit is what is required. But in this instant, the clerk is allowing a notice of appearance to suffice. In light of the case law in this district, defendant has never contended that the clerk could have properly refused to enter a default because defendant's counsel filed a notice of appearance in the interim period between October 11th and October 19th. Instead, defendant contends that the clerk made the right decision for the wrong reason because the Blackburn LR affidavit failed to comply with Local Rule 55.1 in that it did not assert proper service of the summons and amended complaint. The fact that the clerk failed to notice this defect did not make it disappear. The Second Circuit often rejects a district court's rationale for a ruling, but nonetheless affirms the relief granted on other grounds. Similarly, district judges have the freedom to accept, reject, or modify, whole or in part, the findings of recommendations made by a magistrate judge. It would therefore be anomalous that a magistrate judge may not, in deciding whether a plaintiff has complied with Local Rule 55.1, consider anything other than the clerk's stated reason for refusing to enter a default. So they're just going back and forth. They're citing different cases in which this is the case. Significantly, plaintiff's motion does not even address whether the Blackburn LR 55.1 affidavit met the requirements of Local Rule 55.1, nor did counsel address the issue in its submissions on plaintiff's letter motion seeking an order directing the clerk's office to enter the default. However, at oral argument on the motion, counsel did argue that the plaintiff had satisfied Local Rule 55.1 because the return of service upon defendant had been previously filed. However, plaintiff cannot rely upon that document because the Blackburn document did not mention it, much less incorporated by reference. So plaintiff may seek to rely upon cases in which a plaintiff has been excused from securing a certificate of default, and then they reference cases. However, in those cases, the plaintiff's failure to secure a certificate of default was excused because the court had permitted the plaintiff to seek a default judgment without the prior entry of a default pursuant to Rule 55A. Here, in contrast, the court directed the plaintiff to file a motion for a default judgment while explicitly reserving on plaintiff's motion seeking an order directing the clerk to enter a default against the plaintiff. If the court concludes that the plaintiff failed to comply with Local Rule 55.1 and also does not excuse her from that failure, plaintiff's motion seeking a default judgment will be rendered moot. Accordingly, what follows is a discussion of the reasons why a default judgment should not be entered, with assumes arguendo that the court has rejected defendant's Local Rule 55.1 argument. So then they just continue to go into all these different reasons. These are basically glorified paragraphs as to why the default judgment should not be entered. I mean, it is a bunch of legal cases being represented, but it's just basically them going back and forth stating as to why it should not be entered. So now, defendant is not subject to the court's long-arm jurisdiction. The amended complaint erroneously asserted that the court has long-arm jurisdiction over Nicki Minaj, pursuant to CPLR 302. Now, their first point here, transacting business and making contracts. As the court made clear, and then they just cite cases, jurisdiction under CPLR 302 is only permissible where the plaintiff's cause of action has an articulable nexus or substantial relationship with the defendant's transaction of business here. Here, the amended complaint did not allege, nor could it, any such acutable nexus or substantial nexus. Hence, the plaintiff may not rely upon that. Committing a tortious act within the state. Plaintiff also failed to allege facts sufficient to support jurisdiction under this rule, and it has been narrowly constructed to apply only when the defendant was actually physically present in New York when he performed the alleged act. So they are referring to this assault against Jennifer on behalf of Kenny. The amended complaint's sole allegation concerning defendant's activities in New York is that defendant Minaj posted that she was doing a turkey giveaway in Queens, New York on Rockaway Boulevard and 147th Street. Putting aside the fact that giving away turkeys is not a tort, tweeting about it from an undisclosed location is not even an allegation that any conduct took place in New York. So we know that the jurisdiction, when we start talking about New York, we know that Jennifer is suing Kenny and Nicki Minaj separately, but we know that there was events leading up to how all of this transpired, and we now know the infamous turkey giveaway that happened on Rockaway Boulevard. This is all what kicked everything off, and it just kicked off and led to a series of events. So this is why he's referring to it, because he's saying giving away turkeys is not a crime. Tweeting about it from an undisclosed location is not even anything that, any misconduct took place. There's no evidence that anything took place in New York just because they were giving away turkeys. That's basically what he's saying. Alternatively, the plaintiff might be asserting jurisdiction under CPLR based upon the amended complaint's allegations at paragraphs 160, 168, and 175 thereof, that defendants' associates approached the plaintiff's family members in New York and intimidated the plaintiff's family in New York with threats of physical bodily harm if the plaintiff did not recant her 1994 rape claim. So because with this, when they're trying to assert jurisdiction, if crimes happen in the states where they're suing at, they're trying to give evidence as to what actually happened here, other than them giving away turkeys. You're saying that your family members were intimidated in New York, somebody walked up to them and threatened bodily harm, but they're saying none of this happened. And so what does this have to do, the turkey giveaway? Like, how does this prove that anything happened to you or your family members in New York? In other words, the sole agency related allegations in the amended complaint are that unnamed people purportedly acting as defendants' agents approached and intimidated unnamed members of plaintiff's family. And at some unspecified point in time, these allegations do not establish personal jurisdiction over the defendant, because jurisdiction based upon the conduct of an agent requires far more than an allegation of conduct by unnamed associates of a defendant. Rather, a plaintiff must allege that the alleged agent acted in New York for the benefit of, with the knowledge and consent of, and under some control by the non-present principal. So they say that you have to prove that these agents were acting on behalf of Nicki Minaj, Kenneth Petty, and that they sent them. You have to show proof that they knew, that these agents or associates, that they knew, Nicki and Kenny knew that this was happening and that they ordered it. The amended complaint cannot be rationally read as even implicitly making such an allegation. Further, even if plaintiff's agency allegations were adequate, which they are not, the facts alleged in the amended complaint do not give rise to jurisdiction under this rule, nor do they meet the requirements of the Due Process Clause. The allegation that defendants' purported agents approached the plaintiff's family members in New York is tied to the allegation in paragraph 93 of the complaint that two people reached out to the family member stating that there's an offer of $500,000 from defendant Mirage if the plaintiff wrote a letter recanting her rape claim against Petty. Now, count 7 of the complaint describes this alleged encounter as bribery of plaintiff by approaching the plaintiff's family members in New York and offering them $500,000 in exchange for plaintiff recanting her 94 rape claim against defendant Petty. Now they're saying, even assuming if these allegations are true, and they make sure they put in a clause that, but they're not, okay? Even if they're true, but they're not, they do not provide a basis of jurisdiction because bribery is not a tort under New York law, and they reference case. So further, the conduct alleged by the plaintiff would not even amount to bribery under Article 215 of the penal law, because the amended complaint does not allege, as required by the penal law, that the defendant was a witness or a person about to be called as a witness in any action or proceeding. So they're saying that you have to be actually a witness, or you have to be like being threatened because you're going to be a witness called in a proceeding. And so these people are threatening you because you're a witness. So she was not a witness or a person about to be called as a witness in any action or proceeding. And then they reference legal cases. The allegation in paragraph 175 of the amended complaint that the defendant's agents intimidated the plaintiff's family in New York with threats of physical bodily harm if the plaintiff did not recant her 1994 rape claim also fails to provide a basis for jurisdiction under CPLR 302 law because it relates to the allegation in paragraph 168 that the supposed threats to her were committed only to her family. So they're saying that this didn't happen to Jennifer, this happened to her family. So how can you sue Nicki Minaj and Kenneth Petty for something that did not happen to you? But again, this goes back to Jennifer's claims in her complaint that they are threatening her directly and indirectly. Again, it goes back to that, the indirectly statement. Owning, using, or possessing real property within the state. So then now they're just going to go more into the jurisdiction and whether or not defendant neither owns, uses, or possesses any property in New York State. So they're saying that Nicki Minaj doesn't own a home in New York State. So if any jurisdiction would be in that state, you'd have to show that she owns a home. But they did enter into evidence that Kenneth actually owns a home. And later down in this evidence, we do see tax returns that do show that Nicki Minaj and Kenneth Petty in 2019 that they did submit taxes together. So for all those out there that have speculated that Nicki Minaj and Kenneth Petty are not really legally married, we got the tea on that. We do have the tea on that, which we will show later in this broadcast. They filed taxes in 2019 together, so that would indicate that they are connected in some kind of way. They are husband and wife. They may not have the same last name. It did not show on the actual tax returns that they use the same last name. Nicki Minaj still has her last name and Kenneth Petty has his last name. But in 2018, Miss Minaj was alone on her tax returns and showing that she was a resident of California or whatever. She was by herself. But then in 2019, Kenny's name appears. So if they weren't legally married, this would not be a thing. He would not be on that document. So we got the tea on that. We'll show that later down in this broadcast. Now, the defendant did not waive her personal jurisdiction defense. This is just more going into the jurisdiction and just trying to prove whether or not the jurisdiction is in New York. And they just reference more and more court cases. More and more. Plaintiff cannot demonstrate that her allegations taken as true establish defendant's liability on any of the amended complaint's claims for relief. Now, even if the defendant's motion was unopposed and the facts alleged in the amended complaint were thereby deemed conclusively admitted, the plaintiff would still be required to demonstrate those facts. She would have to establish liability as a matter of law, and the plaintiff cannot possibly meet that burden. Now, the court must apply Georgia law, they're saying. They're saying that the plaintiff has ignored basic choice of law principles and instead assumed that she can assert claims under both Georgia and California law, even though the amended complaint did not allege any facts which would permit the application of California law. So we do know when we look at all of the legal filings and what Jen is suing, who she's suing, she did use the state of California. She's suing in Georgia and California and New York for separate claims under each jurisdiction. So they're saying that the court must apply Georgia law because she actually lives in Georgia. Now, here, the application of New York choice of law principle mandates that Georgia law applies to the claims against the defendant because the amended complaint alleged that the plaintiff was living in Georgia and briefly in Florida when the defendant allegedly committed her acts, and that she felt the bulk of defendant's action in Georgia. Further, plaintiff did not allege that she was ever present in California during the period of time commencing in 2018, during which the defendant supposedly wronged her. Hence, the plaintiff's allegations concerning California law are irrelevant, and Georgia law unquestionably applies here. Now, in my humble opinion, and this is just my humble opinion, it doesn't matter, which state the law, what they're going to reference, which laws they're going to reference. Now, I do know that from state to state, there are different laws. I know that different rules apply from state to state. However, this is a broad lawsuit. We are specifically talking about harassment and witness intimidation. I do not know how far the laws vary from state to state, the difference between California law as it pertains to harassment and witness intimidation, and what the Georgia law would, how they would handle harassment and witness intimidation. But I would assume that whatever laws in whatever state, it is what it is. The fact remains that this woman believes she was harassed indirectly and directly through agents of Nicki Minaj. Now, harassment and witness intimidation. The amended complaint in paragraph 157 alleges that the defendant engaged in harassment and witness intimidation in violation of Georgia's harassment statute. Now, it's interesting that they go right into this and they reference Georgia's harassment statute, but they're arguing that the difference between this state and that state, but they go directly in it and they acknowledge Georgia's harassment statute. However, the amended complaint failed to identify any such statute. This omission reflects the fact that there is none. So they're stating that Tyrone's brief, they allege in the amended complaint that harassment and witness intimidation that took place in Georgia was in direct violation of Georgia's harassment statute. However, they're saying that you didn't even reference what the law was. Actually, in the briefing, there was nothing to identify the statute. So the admission, they're saying it reflects the fact that there is no law. They don't know what the law is, which is why they did not include it. Nonetheless, plaintiff now seeks to cure that omission by alleging that OCGA 16-1190 is the Georgia statute referenced in the amended complaint. However, they're saying that this statute precludes a tort claim and no private right of action shall arise from any act enacting after July 1st, 2010, unless such right is expressly provided therein. Because 16-1190 was enacted in 2014 and does not explicitly authorize a private right of action, the plaintiff may not rely upon it in that case. So they're saying this rule that you're referring to, that Tyrone and counsel are referring to, it was not enacted until 2014, so they can't use it. So then they just reference other cases that show that as well. Plaintiff's reliance upon 16-1190 is also frivolous because it does not apply to the conduct alleged in the amended complaint. And then they cite the law, and it says that this law actually says that it criminalizes the transmission of photography or video depicting nudity or sexual explicit conduct of an adult. So they're saying that's what this law references, and this has nothing to do with the case. I would have to agree with them on that. If that is what 16-1190 references, that it criminalizes the transmission of photography or video depicting nudity or sexual explicit conduct of an adult, that doesn't have anything to do with this case. So if they are referencing that, Tyrone, you're dead wrong, because you just now just pulling out anything and just throwing it up on there in the briefing. And now you're hurting Jen by doing that, because that doesn't have nothing to do with nothing. So I'm with them on that. If he just throwing things in there trying to fill up a page, that's wrong. Aiding and abetting. Now, this is the count that is the charge that is being that Nicki is being accused of. She's being accused of aiding and abetting Kenny, stating that she knows he's a known sex offender and that she encouraged him not to register once she got with him. So they are referencing that, and now they're getting ready to countersue it. They're getting ready to counter strike it, and they getting ready to have a goddamn rebuttal. And here it goes. Now, the plaintiff has failed to state a claim for aiding and abetting because she has failed to identify the underlying conduct which defendant supposedly aided and abetted. This is not an insignificant omission because, in contrast to other states, the Georgia courts limit the types of torts for which liability can be predicated upon aiding and abetting. So they're saying that you have to have specific, be able to cite specific cases where someone is aiding and abetting in Georgia. And what is it that you're saying she did? You gotta know, and Nicki's gotta know exactly what she did to aid and abet. So given that the plaintiff has failed to identify the conduct that defendant purportedly aided and abetted, she has not provided the court with a basis for concluding that count 5 is viable under Georgia law. Now, in my opinion, this is not true because Jen and Tyrone and them over there down to the plaintiff's counsel table, they did state in the briefing where she aided and abetted and why they feel she's aiding and abetting. Again, even I know why they're using that. They're saying that Nicki Minaj feels she's above the law. Now that Kenny's with her, you're above the law too. And you don't have to report as a sex offender. You with me. You don't got to report. That's clearly aiding and abetting. When you know a known criminal, he's supposed to report and you're not encouraging him to do so. This is aiding and abetting. Now, further, in the best possible case for the plaintiff, she's only alleged that the defendant aided and abetted the harassment and witness intimidation claim set forth in count 5 because count 4 is based solely upon the allegations in the preceding paragraphs. I don't believe that. I'm sorry. I'm going to have to disagree with that. They specifically list in the declaration exactly what she was aiding and abetting. So I'm going to have to not agree with that. I don't agree with that. I just don't. A lot of these paragraphs, if you read them, it's a lot of legal jargon. So please bear with me. I'm trying to understand it as I go along and read it and help you to understand it because I briefly looked over this. And a lot of it is the same stuff over and over, but just twisted in different wording. I believe that they do this in an attempt to just really just throw a lot of information at people, and people just, you know what, I'm not reading all this shit. Like if I had to sit down, it would just, I'm not reading all, but that's the judge's job. He's got to read it. But I mean, I think it's an attempt to, just boggle people down with a bunch of words, a bunch of legal. It's just like, stop. Say what you're going to say. Be done with it already. It's just the same shit over and over and over and over and over. So now we're just going through, of course, I'm not going to read all of this. Like I said, I'm skipping a lot of it because this is all the same wording over and over and over. All right. So we come down. And again, this is just more of why the default judgment should not be granted. That's point 5 is another paragraph stating why it shouldn't be granted. It's just, that's basically what this whole entire thing is. Now, when we get down to here, this says, now this is B. Now this statement, this is Nicki Minaj's lawyer, all right? It says, defendant's default was not willful. All right. Now she's saying that she was late responding to the lawsuit, but it wasn't willful. She didn't do it intentionally. I don't know what other intentions it is, but all right. Plaintiff's claim that the defendant's alleged default was willful is as frivolous as her claim of prejudice. For a defendant's default to be considered willful, her conduct must be more than merely negligent or careless. Now, I don't know why this would not be considered careless to not respond to a lawsuit, to be late, to, just totally disregard the rules. In my mind, that's careless, but I'm not a lawyer. So he's saying that it wasn't careless and it must rise to the level of egregious and not satisfactorily explained. And then it goes into other, lawsuits or whatever where this was done. Willful default found where defendants' 14-month delay in answering the complaint was a part of an overall plan to delay the proceedings. That's just really, that was citing something else. I don't know, child. This is, these people is just too much. While the plaintiff points to media attention, and they're saying Nicki Minaj was able to be all in the media, but she couldn't respond to the lawsuit. Now, they are acknowledging that. They're acknowledging that the plaintiff is saying this about Nicki Minaj, but they're getting ready to rebuttal it, all right? They said, while the plaintiff points to media attention and defendant's efforts to retain counsel, speculating that the defendant chose not to take this litigation seriously, that notion is absurd, given that the defendant's counsel filed a notice of appearance just 8 days after the purported default. They were 8 days late and they still did not respond to the lawsuit. They filed a notice of appearance, which was the easiest thing that they could file in court. That is basically just a paper where the attorney is stating, I'm representing Nicki Minaj. I'm going down to the courthouse, filing this simple piece of paperwork that says I'm going to be the attorney. It is not a direct response to the litigation. So you think that we're not taking it seriously? You think Nicki Minaj is not taking this seriously? We only responded 8 days later. That's absurd to think. 8 days? 8 days out of the timeline. 8 days. But, that's not willful. Doesn't mean that she thinks she's above the law. She didn't have time. She was on Twitter. She was on Instagram. But she didn't have time. She couldn't do it. She didn't have an attorney. She knew she had a lawsuit, but she said she didn't. She didn't know. She was looking for an attorney. She was shopping around. She was getting references for a lawsuit that she knew absolutely nothing about. She claimed she didn't know nothing about it. Why would you need an attorney? Would you need to shop around for an attorney? These are just my humble questions that I have for the defense. Why would you have to shop around for an attorney if you didn't know anything about a lawsuit? Those are the questions that I would be asking as a judge. I'd be looking at this stuff and I'm saying, now Bernstein, all of this legal jargon, I'm reading this brief, but I just have one simple question. Why would a defendant need an attorney if she knew nothing about a lawsuit? The plaintiff has, she has not offered any meritorious factual defenses. They're saying that Jen has no factual defenses. Initially, we note that the plaintiff misunderstands the rule that upon entry of default, a defendant is deemed to have admitted all well-pleaded factual allegations of liability except those relating to damages. On a Rule 55 motion, this language means only that in the first instance, the plaintiff is entitled to the same presumptions afforded on Rule 12b6 motion. The court must accept all of the plaintiff's factual allegations as true and draw all reasonable inferences in its favor. However, in contrast to Rule 12b6, the court may consider whether material issues of fact remain. For example, in Meehan, which is a court case, the court found that the district court's application of Rule 60b meritorious defense required instead of Rule 55C, less rigorous standard, was erroneous because the district court thereby failed to assess the defendant's denial that money was due for legal services and that the alleged defamatory statements had been made. Our analysis of the law on this point is confirmed by the dockets of the cases upon which the plaintiff has relied in support of her deemed to admit argument. Those dockets reveal that the defendants in each of those cases did not appear in oppositions to the plaintiff's motions for a default judgment. Now, this is just more, like I said, they keep on sneaking on back to that default judgment. They keep using this case and that case, referencing this case and that case. That's what I keep gathering from this. They keep sneaking on back to that default judgment. Now, there's got to be a reason Now we're going to put our thinking caps on here, okay? We're going to jump on out of this and we're going to have constructive dialogue really quickly. All right. Why do they keep mentioning this default judgment? Why do they keep badgering the judge with why this should not be issued? Now, if everyone wants to say that Jen is not going to win this, they are not going to issue a default judgment, the judge will never do that because it's a lot of money that is at stake here and that they should not even entertain it. But in my humble opinion, these attorneys know better. They know that that's a wild card and that it can absolutely happen. Anything can happen. Anything. So there's a reason why they keep sneaking on back to this default judgment and they keep hammering. This entire brief, this entire declaration is dedicated to the default judgment and why it should not be entered. So we know that, why it should not be honored. But you would think that there would be more evidence. There would be more, they would have more than this. But they're using this case, that case. They've referenced over, it has to be over 50 some legal cases, okay? This brief is loaded. Look at all of this. This brief is loaded with examples of cases discussing a default judgment. Now, if it wasn't that important and Jen was not leading the charge, and this couldn't be something that could be a thing, and she might not pull a rabbit out of the hat, Tyrone Blackburn might not be getting down into that courthouse and just might not beat, he just might beat defendant Mirage and defendant Petty, then why are they taking so much time? Why are they referencing it so much? In my opinion, I would just move on. I would just move on down and I would just pull all my rabbits out of the hat. This lawsuit is meritless. It doesn't have any points to it. I wouldn't keep referencing it, but they are making a point to continue to reference this default judgment. Now, here the defendant has a number of merited factual defenses. First, she has, to the greatest extent possible, explicitly denied under oath each and every material allegation against her in the amended complaint on a paragraph by paragraph basis. So they say that Nicki Minaj has denied every allegation on a paragraph by paragraph basis. In a case where the plaintiff alleges that third parties acted at the direction of the defendant, and the defendant does not yet have the ability to conduct discovery, she can do no more than she has done, and her denials are sufficient to establish a meritorious defense because she will prevail at trial if the jury believes her. Now, he was very adamant that she's going to prevail at trial, but then he says, if the jury believes her. So the jury has to buy this shit. They got to buy into it, Nicki Minaj and Kenneth Petty. They got to believe it as well. So even if she does all the denying in the world, once they pull out that discovery, and they just admitted to that, they don't have the discovery yet. Nicki Minaj doesn't have the discovery. She doesn't know what evidence Jen has. We're not at that point yet, ladies and gentlemen. So the defense has admitted to this, that we don't got the discovery. So she can only do what she's done so far, and that's deny that any of this is true. I did not harass this girl. I didn't use agents to send her money, to offer money, to ask her to recant her. I didn't do any of that. But remember, the jury got to believe your ass too. Right? They admit it. They admit it here. Jury got to believe you as well, Nicki. So now they reference another case and they says that in this case, Campbell had explained briefly that he intends to defend himself against the plaintiff's accusations by establishing that the plaintiffs have mischaracterized his conduct and that all of his interactions with the plaintiff had legitimate law enforcement purposes, free of animus or ulterior motives. So it's odd that they're referencing a case where this person in this case They had to show that their conduct was as a result of interactions with the plaintiff and that they had legitimate law enforcement purposes, that they they were mischaracterized and that they really didn't do any of this. They had no ulterior motives. So it's odd that they reference a case where they're citing that, because what would it there definitely is ulterior motives. Why would you reference a case where this person is saying they didn't have any ulterior motives? Nicki Minaj and Kenneth Petty absolutely had ulterior motives because they wanted her to recant the story. That's the ulterior motive. The motive is drop the story, recant the story so that I can get a new case and get a new hearing and that I can be removed from the registry. But we know that that's not going to be a thing because the state of New York, we covered that, they want to deny and they want to throw out the case entirely. They don't even want to entangle with this plea deal. They don't even want to honor Kenny a plea deal anymore. They want the case dismissed entirely. So why would you reference a case such as that? So now I'm really, when I get into these documents and I read them, I actually see things different than other people. People would dive into this and they would read this stuff and they would say, Jennifer is losing. She's absolutely losing this case. Look at this lawyer. Look at all this fancy smancy paperwork. But in my opinion, it is 109 pages. Okay, come on. 109 pages to do what? Say what you have to say. Why are you beating around the bush? And why are you beating down the judge's ears with why? I mean, we are an hour into this video already, and I'm not even nowhere near done with these papers. Okay. So it's like, if you really got something and you feel like your case is heading in the right direction, you wouldn't need to do all this. You wouldn't need to say all this. Just bullets, boom, boom, boom. This is what we have. Boom. But all of this got to reference this case, that case. I got to pull this out, and it's just too much. Now, second, Exhibit B, to defendant's declaration is an August 31st, 2020 text message sent to the defendant by the plaintiff, which standing alone could cause a jury to reject the plaintiff's testimony on credibility grounds. If that were to happen, the plaintiff would necessarily lose her case because she is its linchpin witness. So there is a text message that we are going to read, and allegedly this came from Jen. Now, when you see this text message, it does not show the phone number, doesn't show the contact name at all. It is simply is a text message from a user where it says, U.S. Marshal is asking questions. They showed up at my door. It completely contradicts the plaintiff's claim that the defendant threatened her or that she was in fear of her, because the amended complaint alleges that by August of 2020, the plaintiff and her family had been threatened by people supposedly working on defendant's behalf, and that she changed her address because she was afraid for her safety. But if this were true, the plaintiff would never have sent defendant a text message asking for help because law enforcement had come to her door. That is the last thing someone who was supposedly being threatened by supposed gang members would do. But this is the first thing suggesting that there was a danger to defendant of criminal charges. That's someone who was looking for a payoff, and that's what a person like that would do. Now, in my opinion, I'm going to show you this text message, and we're going to look at this together. Now, we're going to scroll on down. Hey, Miss Bree, thank you for the super sticker. Now, we're going to scroll on down, and we're going to look at this text message. Now, if Jen sent this to Nicki Minaj, why did they not specifically show that it came from her? There's no phone number. It's not even a contact that says Jen, Jennifer, the op, whatever, bitch. Nothing. Nothing. It simply just says they showed up at my door. The marshals showed up at my door and they're asking questions. That's it. So I'm going to scroll on down to show you, because got to show the receipt. Got to show the receipt. Now these are all those. We're gonna get to those emers. And I'm telling you, these are I mean, they have entered certain things as exhibits. I'm just like, why would that be entered? All right. Now, this is allegedly the text message. Okay. This is the text message. Now, it says 678. All right. And the rest of the number is blocked out. And I'm assuming, they know, the courts know that this information is being viewed by the public. So it's some stuff that they do blot out, like the tax stuff we're going to look at. They blot out certain things. However, this doesn't show us anything. You don't know if that number is Jennifer's number. We don't know. That could have come from anybody. You could have sent that to yourself. You could have had a phone in another name and you could have sent that to yourself. August 31st, 2020 at 12:49 p.m. U.S. Marshals are asking questions. They showed up at my house. Now, they were dead heated in debating around this time. They were absolutely enemies. There would be no reason for Jennifer to be contacting Nicki Minaj and to even speculate that this girl had Nicki. Now, why would she have Nicki Minaj's phone number? Those are the questions that I would be asking. If I was a judge and I was, viewing this case, I would say, well, how is it that she has Nicki Minaj's phone number? How did Jen come by Nicki Minaj's phone number? How would she have a world-renowned celebrity's phone number? That's number one. I do not believe that Jennifer has Nicki Minaj's phone number. I don't believe she even knows how to get in contact with Nicki Minaj directly. I don't believe she could just pick up the phone and dial Nicki Minaj. To even think that that was true, I don't believe that. This could be anyone. This could be any number. This could be Nicki texting herself. So to me, this would have to be proven that this is Jennifer's number. I need phone records. I'm pretty sure they're going to do that. They will tie this number to Jen. If this is Jennifer, they'll be able to tie it to her. So if this is, they would be able to tie this through. And I'm pretty sure that Tyrone and them people over there, they know that. Down to the damn plaintiff office. They know this. So I'll be asking that question. Well, first of all, if you want me to believe that this is Jen, I need to be able to tie this number. Give me some other proof or something that this is Jennifer. And how is it that she has your phone number? So that's a question I would be asking. I don't believe that this is Jen. But that's just my humble opinion. Let me know what you guys think in the comments. You think this is Jen? Y'all think this is Jen? If you're catching the replay right now, put it down there. You think this is Jen? If you in the chat, let me know right now, Nita. Is this Jen? This could be anybody. Come on. Come on. Y'all got to do better than that. Could be anybody. Right? All right. So where we at? So they're saying, that's going to blow this case wide open. That's going to blow this case wide open. If that was really Jennifer, why is she contacting Nicki Minaj? They're supposed to be enemies. So that's just going to blow this case wide open. And if a jury was to see that, if they were to get their hands on that, they would just dismiss this case. She'll be the laughing stock of the court, and we could just go on about our day. This court case would be dismissed. But I don't think that we're going to get off that easily. Not going to get off that easily. All right? Because you got to prove that that's Jennifer. Now, as we go down more into this, they start to talk about the process server. And they start to allege again that Kenneth Petty was not properly served, him and Nicki. That the process server got it wrong. Mr. Petty is not 200 pounds. His height, the difference between 5'10", just the difference between 25 to 30 pounds. It's just all of that is in this, okay? That's where they start going into it. And they saying that Diaz, that he's a liar. He didn't serve Kenneth. Now, I keep saying this. I find it hard to believe that a process server would lie. and that he would say he served someone if he did not. So now they are directly coming at his statements, and they directly coming at the part where he was yelling over the telephone, where he said he heard Kenny yelling over the telephone. Diaz also provided varying accounts of what actually transpired with the security officer. In the Diaz October declaration 10 through 11, he stated that when he returned to where the security officer was located, he heard Mr. Petty yelling at her because he was upset that she let Diaz into the compound. He then returned to the house after hearing this. In other words, Diaz's declaration did not state that the security officer told him that Mr. Petty was yelling at her. It stated that he went back to the house solely on the basis of having heard Mr. Petty yelling over the telephone. But Diaz's declaration also makes clear that he had never spoken to Mr. Petty prior to that day. So he would not have any way of knowing that in fact was Mr. Petty on the phone with the security officer. Now, who else would it be? Who else would the security officer be allowing to yell at them about someone entering the compound? Now, again, these are contradictory statements that are being made by the defense. They are contradicting whether or not they were properly served. They're saying this is not the case. This man didn't serve them. And how could he have known that somebody talking on the phone was yelling at the security guard and that person was Mr. Petty? How did you know? How could you hear through the phone? Now, that I'm going to have to agree with them on that. Okay. I need to understand, how loud was Mr. Petty that you were able to hear that goddamn phone call? He must have been extremely loud if you were able to hear it. All right. I need to know how loud, because I don't know if it was a cell phone. I'm going to assume that the security guard was talking on some sort of cell phone. Or was the security talking on a walkie-talkie? Was it some type of device that was a speaker? Because if so, then it's absolutely plausible that he heard Mr. Petty's voice. If it was a speaker, if it was a walkie-talkie, yes, he heard it. So this is just them going more into trying to contradict the fact that whether or not they were really served and blah, blah, blah. So they're going back and forth with that. And they're just basically trying to call Diaz a liar. They flat out saying he was a liar. Period. All right, so now plaintiff's cursory alternative argument that Diaz may have served someone who appeared to be residing at Mr. Petty's residence fails. Plaintiff appears to be advancing an argument that the service was proper under federal rule, blah, 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 by contending alternatively that even if Mr. Petty was not served, the person whom Diaz served appeared to be a person of suitable age, which was the age of 40, and discretion at that time lies with the process server, because you can absolutely say, well, this is an adult. I'm going to leave this with them. He seems to be a responsible person. You're going to give it to Mr. Petty. Plaintiff mistakes the law. Rule 4E2B provides that an individual may be served by leaving a copy of the summons and complaint at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there, not someone who appears to reside there. Regardless, Diaz did not explain how he could have known whether someone other than the person that he assumed was Petty, but it really wasn't. He's saying this person, he may have been seen as an authority to accept the service, but how did you really know? You never spoke to anyone. Now, I'm going to have to disagree with that, because in his statement, he said that he looked at the person in the window. He knew it was Mr. Petty because he had a picture of him. He used the picture of Nicki Minaj and Kenneth Petty when approaching the residence. And by looking at the person, he determined that it was him. And you don't want to take this from me, but I'm going to leave it here. He showed it to him. So I'm going to leave it here. So I believe that it was a proper serve. But this is something, again, that is going to be discussed at the time of during the court. This will be brought before the jury and they'll have to decide, was it a legal serve? All right. So that's where this concludes at. With this part of the declaration is actually done. They finally rested and they finally came to a conclusion. All right. Now, this is actually Onika's, when you start getting into this paperwork, this is Onika's her declaration. And this is basically all of her statements where she's saying what she is, basically swearing to. What she's swearing to is true as far as the serve is concerned. She's saying again, basically, that they were not served. So they said, this is my statement and I'm sticking to it. So now when we get into Exhibit A, these are actually emails that have taken place between Tyrone Blackburn and team and Judd Bernstein and team. Now we know that Judd Bernstein represents Nicki Minaj and Tyrone and team represents Jennifer. Now these emails, they have been fighting, going back and forth. Each side basically saying what is admissible in court, how court rules go, and this is what they want. Now, on October 13th, this is an email that was sent to Judd, and he's saying, you can file your opposition and explain to the court while your client believes that her and her husband are above the law. I do not consent to an extension. Now, this was around the time when they were asking, and as we can see here, this was Mr. Judd Bernstein sending to Blackburn, I expect to file a notice of appearance tomorrow on behalf of Nicki Minaj in the above referenced action. I'm aware that you filed a request for certificate of default on October 11th. I'm writing to ask that you voluntarily withdraw your request and agree to an extension of time until November 1st to answer or move against the complaint. Otherwise, we will both waste our time litigating a motion on which Ms. Mirage will surely prevail to set aside the default. Please let me know whether you agree to my request at your earliest convenience. And that's when Tyrone sent back, no, we do not consent to your extension, and we'll see you in court. We're going to move forward with our default judgment. Now, it's interesting to note here that Mr. Bernstein stated that Nicki Minaj and counsel were going to respond to the lawsuit by November 1st if they were allowed an extension of time. And it's interesting to note that they still have not answered to the request. They're saying that if you voluntarily withdraw your request and agree to extension of time, we're going to answer or move against the complaint by November 1st. So even still, they said no, we are not going to go along with any type of extension. But in this email, they're stating that they acknowledge that they have to move or answer to the complaint. They didn't state that we're going to issue a letter to the judge asking for more time. We are going to issue ask for pretrial conferences. We're going to issue letters asking that we're allowed to go away to. They didn't mention any of that. They acknowledged that they needed to answer or move against the complaint. So why had they not done so? Again, this is a tactic. This is, them trying to stall, trying to delay, and basically, in my opinion, waste the court's time. You know what the proceedings are. You know what you're supposed to be doing. This is why Tyrone is ticked off, and I would be angry as well. Thank you, Marcella. She says, my two questions are, why is Nicki supporting this mess? And why are they just fighting? And why they just fighting? Face the music. Why keep fighting? Right. Go to court, Nicki is risking a lot. Right. And I agree with that. I don't know why Nicki is supporting it. You would think as someone of her stature, as someone of her professionalism, the type of person that we know Nicki Minaj to be. I mean, I am not I'm not overly a fan of Nicki Minaj, but I don't have anything against her. Now, in this, her behavior, how she has decided to carry herself and chosen to move through this whole thing and be supportive, I just can't get behind her. I can't get behind her decision to be with someone like Kenneth. I don't understand that. I don't understand why she decides to represent him in this light. I don't know why she decides that, now I know as a wife, she has his back. I get it. But she can decide to stay out of the spotlight with this. She don't gotta be, you know what I mean? Like Nicki Minaj is a celebrity. Everyone says Kenny is abusive, he's this, he's that, but she don't gotta put her name on this. She don't gotta put her brand in jeopardy of this. She can distance herself from that. I'm pretty sure her publicists and people around her have told her that, but she, their handlers, they work for her. They bow down. Whatever she want to do, she does. Quite obvious. But I'm pretty sure PR managers, people have told her to get away from this. It's ruining your brand. Get away. You know what I'm saying? But we know Nicki Minaj, she's not doing that. She's supporting him. So I don't know. I think she should distance herself from it. Now she needs to just go to court. They need to just get it over with. Your attorney needs to respond. He admits in this email that they're going to either move or answer the complaint if you allow us an extension. So it's giving. You didn't allow the extension. You didn't play ball. So now we're going to drag this shit out. Now we're going to fucking drag it out. We're going to drag it out. And for those of you that do not like it, I'm sorry, but every now and then I say a curse word. I'm an adult. I'm grown. I'm giving my banter. I get a little frustrated from time to time. And I might say a little cuss word. So if you do not like foul language, please click off the video. This is not the video for you. You can catch, I have done 2 other uploads today. You can go on over there and watch those. This isn't the place for you because we're going to curse here. We're going to curse. We're going to say, we're going to have our little banter. We're going to talk our little ish. So this is not the place. All right. So I'm not going to hold that against you. I still love you. I hope that you still love me, but you can go on ahead and excuse yourself because we're going to cuss in this video. All right. All right. Now, Exhibit B, there are net more emails between the 2 attorneys, right? On Friday, October 22nd at 5:16, Tyrone sent this to Stephen, Sierra's, and Judge Bernstein. All right. Basically, your motion for leave to amend the complaint. He's basically sending this to Nicki Minaj's team. All right. To add to what Stephen said, in light of your position, Judge, I think it is essential for us to have a traverse hearing and we will petition the court for one. And then Judge says, I'm not quite sure why you're both continuing to make legal arguments when this is a procedural issue or why you need my consent for a traverse hearing. If you are entitled to one, the court will order it, perhaps, or my consent after I review the law. If you don't want to agree to simultaneous briefing, that is your right, and maybe the court will agree with you. You should then write to the court and include my email with my proposal. Now, he trying to act like he don't know what Tyrone is talking about, but it is obvious that prior to that, Stephen was in contact with Judd, and then Tyrone was just adding to that because Stephen had done said at 5:13 on that day, Judd, perhaps you are thinking of state court or where this is a some certain. But below is how it works. Nonetheless, we will file our letter with this email chain attached. All right. So he gives him how the law works in reference to filing a certificate and request for a certificate of default. And he says, now I'm going to give this to the judge. I'm going to include this email with our letter. All right. Now I'm going to tell on you. Now I'm tired of you. I'm going to tell the judge. Now I'm going to include these emails because we don't have anything to hide. And so then judge says, that's just not the way it works for a default, nor do I want to litigate by email. If you don't agree with my proposal, write to the court and annex my email so that the court has both of our points of view. So if you're going to put it in there, go ahead and put it in there. And then basically Stephen is basically telling Judd what they've done, going back and forth. We're requesting the default judgment. We know that you're stating that Tyrone, that Mr. Petty was not served. We know that your client is saying she was not properly served, but the affidavit of Diaz's serving is what we're going to include and send to the judge because it shows that the service was proper. And then he said, given that you are calling our process server and Tyrone and I, who are officers of the court, liars, I'm assuming that means you will consent to a traverse hearing. That way we can subpoena Mr. Petty to appear on the stand and swear under penalty or perjury that he was not served. We will also call our process server to the stand and submit additional documentary evidence that the service was proper. We can let the judge decide who he believes, and then we will move for sanctions based on the untruthful declaration that your client submitted, as well as your baseless claim that we're lying. Accordingly, we will also immediately advise the U.S. Attorney for the Eastern District of your client's and Mr. Petty's perjury. I'm sure that will assist him during his January 2022 sentencing hearing for failing to register as a sex offender. Ooh, they are petty. Jen over there, she done got some lawyers that are petty. They said, so you calling us a liar? You want to say that our process server, officers of the court, Tyrone and I, that we are liars. So you want to actually state that Mr. Petty wasn't served. Okay, so how about we subpoena Mr. Petty and we put him on the stand, make him raise his hand and swear under penalty of perjury that he was not served. And then when we prove that he was served, we will sanction him and we will make sure that he is charged with perjury. And I'm pretty sure this will help his 2022 sentencing hearing where he's failing to register as a sex offender. We know that he's got that coming up in January, but we know, because we broke that T, that the court is actually reviewing the defense's motion to dismiss that entire case. All right. So the plea deal that's on the table for that might not even be a thing because they want to dismiss it entirely. They saying his statute of limitations ran out, amongst a few other things. You can go on over there and check that video out. But these people are petty. These lawyers, Jen ain't playing with it. They said, listen, you want to lie? All right, let's play ball. Get up on that stage. I'm sorry, stage. Get up on that stage and twerk some things. No, get up on that stand and raise your hand. Put your hand on that Bible. Put your hand on that Bible. And say that you weren't served. Because guess what? Our process server, he going to have his documents. He going to be able to prove that he served that thing. So let's do this. Let's do it. We will submit our motion for entry of default judgment 10 days after the certificate of default judgment is issued. You then have 10 days to file your opposition. So this was with respect to the schedule. We are fine with my letter and your letter serving as the motion in opposition for the certificate of default judgment, but propose that we are to submit our reply papers by next Friday, October 29th. If our motion is granted, we propose the following schedule. Now, this was back in October when they actually gave them what they were going to do, and they still didn't stick to the schedule. It says, we will submit our motion for entry of default judgment 10 days after the certificate of default is issued. You then have 10 days to file your opposition. We will then have 7 days to submit our reply. If our motion is declined, we propose the following. We have 10 days to file our opposition, after which you have 7 days to submit your reply. If you do not agree with this schedule, we will file our letter to the judge and have him decide. Now, none of this is actually, none of this happened because this was not denied. We're still waiting on the judge to rule on it. So then judge said, I disagree for the following reasons. Defendant's motion could not have sought relief from a default because no default had been entered. It asked for permission to file a late pre-motion conference letter, thereby obviating any default which might be entered. It thus is legitimately the first filed motion. More importantly, defendant's motion analyzed the law as though a default had been entered. The substance of my motion has now changed, but the circumstances have because the default has been rejected. While you assume that your letter motion will be granted, I do not know why you believe that to be given so you did not file an affidavit concerning service of the complaint, and you know that your process service affidavit erroneously claims that he served Mr. Petty. I therefore suggest the following schedule. We will consider the letter I sent in response to Stephen's letter concerning the clerk's refusal to enter a default as defendant's full response to plaintiff's letter motion. Plaintiff will respond to defendant's motion on October 29th or later if you wish more time. The parties will each file relied papers on their prospective motions 10 days after the date. If the court directs the clerk to enter a default, the briefing on the defendant's motion will be deemed to be a fully briefed motion to vacate the default. I note that you are not obligated to file a motion pursuant to Rule 55B immediately, and if the defendant were to lose her motion to vacate the default, it will remove a major obstacle to securing a default judgment from the court. Now, none of this, of course, has taken place because this is still an argument. We're still here reading Judd Bernstein's declaration. We just got done reading it. He submitted yet another one to the court stating why the default judgment should not be issued, why they should not overrule this, why they shouldn't overturn it, why Nicki Minaj should not be allowed a default judgment. So none of this has taken place. We're still waiting to hear from the judge, still waiting on the judge's order. So these attorneys continue. They just go back and forth, and they are not backing down. They don't back down. Tyrone and them, they don't back down. They said, we do not care if you are a renowned celebrity with these attorneys. We don't care because we're not backing down. Now, Exhibit D, this is actually that graph that we read in detail. This is the graph that shows the allegations in the amended complaint and actually the March 4th Daily Beast article. This just breaks down the discrepancies and differences that they say exist. So we already read that, but this is just the exhibit that has been put in a graph. It's more side by side, and it's, but we read it. All right. And then this is Exhibit E. This is just, an envelope. Exhibit F is an article. Nicki Minaj and husband Kenneth Petty's campaign to silence his sexual assault victim. And then they have the article in here as an exhibit. Child. And then the declaration of Nicki Minaj again. Now, this is her actually. Okay, so this is her. Okay, so this is her actual declaration for this entire court case. So she says, I am a defendant in this case. I submit this declaration in opposition to plaintiff Jennifer Hough's motion for a default judgment against me to be set to a set date for an inquest. This is the second declaration which I have submitted in this case. My first declaration was addressed to the issue of whether I was properly served with the amended complaint. I have annexed that declaration as Exhibit A here too and incorporate it by reference herein. So this is her declaration speaking to this default judgment that is against her. She's saying this is my second declaration. The first one is me lying, saying that we were not properly served. Now this is me now coming before you swearing now, because when they write these briefs, you see here, declares under penalty of perjury. Give me one moment, guys. Give me one moment. I got to grab something. Give me 1 second. Y'all go ahead and talk briefly in the chat. Y'all go ahead. If y'all got some questions, throw one down in there, but give me 1 moment. All right, I'm back, guys. Okay, sorry about that. I had to grab and get the stuff out the oven, child. All right, I got me a late night snack. So let me get this video over with. All right. So the purpose of this declaration is to state the facts concerning the false allegations against me in the amended complaint and other papers filed in this case and my contacts with New York State. Plaintiff's counsel has made false claims about events after the amended complaint was filed and my supposed gang membership. I am advised that plaintiff's attorney, Tyrone Blackburn, has submitted a declaration stating on October 23, 2021, Petty and Mirage were both in this district in Jamaica, Queens, New York, as seen on an Instagram live video currently up on Mirage's Instagram page. Both Mirage and Petty were seen associating with members of the Make Baller set of the Bloods gang. Petty and Mirage are both members of this gang. Petty can be visibly seen posing and throwing up gang signs with his fellow Make Ballers Bloods gang members. On October 23, 2021, shortly after Petty and Mirage were spotted with their gangster colleagues, a member of the gang posted a death threat to Ms. Hough on Twitter stating, "Jennifer, if you see this, the Makes are coming to get you." Now, plaintiff's counsel claims that my husband and I are members of the Make Ballers or any other gang. Now, this is outrageous and completely false. Further, I did not direct, approve, or know about anyone posting any message on Twitter mentioning the plaintiff, including the message stating, "Jennifer, if you see this, the Makes are coming to get you," which the plaintiff says she received. As for what happened on the night of October 23rd, 2021, here are the facts. Now I want to see this. I want to see this, okay? I want to see what she is going to say in opposition to that because I need to understand when we see that live and we all watch the live, we've seen it. What is it that what do they want us to come away thinking? What do they want us to come away thinking? When you watch that video, what is the purpose? And I need to know this. When people post things on Instagram and they are with gang members, they throw up gang signs. If you're not a member of a gang, why are you with known gang members and why are you throwing up gang signs? Why are you saying slut, slut, slut? Pull up, pull up. Why are you saying those things? If you are a grown adult man and Nicki Minaj is an adult woman, who is also a celebrity. Oh, she's a world-renowned celebrity. Why are you in the streets of Jamaica, Queens? Why are you out there with a group of men, no other women around? You are with a group of men that are known gangsters and you're affiliated with them. You're throwing up signs, you're screaming out loud, saying people to pull up. You're making all of these noises that are gang signs, gang noises. Like, you're affiliated with these people. If you're not affiliated with them, why are you there? I am not in a gang. I know no gang members. I'm not around anyone that is throwing up gang signs and I'm not making gang noises. I'm not posting any of that on my Instagram. I don't know any of these people. So why would you be associated with them? I mean, to even think, coming away from watching that video, what else are you supposed to get from that? I need to know that. Now, she says that this is actually what happened on October 23rd. Here are the facts. All right. That's in bold. All right. It's in bold black. So that means it must be true because this is facts. On October 23rd, 2021, my husband and I were driving with our baby to visit my husband's grandmother in Jamaica, Queens. As we were driving there, we saw a huge mural of Sean Bell, a man who in 2016 was shot and killed by the New York City police in Jamaica. My husband and I decided to stop and look at the mural. We did not plan to stop at that location, and we had no plans to meet with anyone there. However, as it always is the case there, when I appear in public, I was quickly surrounded by my fans, particularly in this instance because my Pink Rose voice was in the direct sight line of apartment buildings across the street from where I had stopped. While my husband and I recognized a few friends and acquaintances from the neighborhood that night, including Rico Dana, an artist whom I intend to sign to my label, none of them belonged to any gang. Further, we did not plan to meet anyone in advance because we had not planned to stop there. Once I came out of the car, the news traveled quickly and people just showed up. Neither I, my husband, nor anyone I knew made any gang signs that night. I did not mention plaintiff on this case that night, nor did I hear anyone, including my husband, mention the plaintiff on this case that night. We know that. We know that you're not going to be that foolish to mention Jennifer. You're not going to be that foolish to mention the case. We know that. No one said that you did. No one said that you mentioned anything like that. I videoed my time on the street that evening and I streamed it to live on Instagram. However, as is almost always the case, when I do a live stream, I made the decision to do so on the spur of the moment and it was not advertised in advance. Who said anything that it was advertised? Like, what does that have to do with anything? I need to understand during that video what was being said in the video. When we come away from that video, we see gang signs being thrown. We hear Kenny. We see Kenny. We see him with the other members of said gang. And these people are known to be members of that gang. Kenny makes no, he doesn't hold back any punches. He knows exactly what he's doing. He knows exactly who he's around. We know those people because you're spotted with these people on multiple lives. So it's just not giving, sis. It's not giving. It's not giving truth. Plaintiff sent me a text message which demonstrates that she's lying. So now we're going to make reference to the text message that we showed earlier. Other than the plaintiff's allegations that I gave away turkeys in Queens in 2018, and I twice defended my husband on social media, every other allegation against me in the amended complaint is either false or misleading. However, before even discussing the plaintiff's allegations in the amended complaint about my supposed conduct, I want to inform the court about a piece of evidence concerning plaintiff's conduct, which unquestionably shows that she's making the false accusations against me because she mistakenly believes that I will allow her to extort me. Annexed here too is Exhibit B, that in August 31st, there's a text message to me from the plaintiff. As mentioned below, I had previously given the plaintiff my phone number. Her text message reads as follows: U.S. Marshals are asking questions. They showed up at my house. This text message completely contradicts the plaintiff's false claim that I threatened her or that she was in fear of me because the amended complaint alleges that by August of 2020, plaintiff and her family had been threatened by people supposedly working on my behalf, which never happened, and had changed her address because she was afraid for her safety. But if this were true, she would have never sent me a text message asking me for help because law enforcement had come to her door. That's the last thing that someone who was supposedly being threatened by supposed gang members would do. But it is the first thing suggesting that there was a danger of criminal charges that someone who is looking for a payoff would do. I now turn to the other allegations in the amended complaint. Now, I want to just briefly cover that really quickly. If this text message is from Jen, I need to understand, why would Jen have your phone number? And I don't know, why didn't you have her listed in your contact? Why is there no name? Why is it just a phone number? If y'all was on a basis of communicating with each other and you just knew that was her by the number, why is she not in the contact? Why is there no name? It's just a phone number. All right. So that's my first question. And then I need to understand that, why are you saying that she, I'm sorry, wait a minute. I skipped. Oh, okay. So she's saying that she wants to extort her by sending this, by putting her into a court case, but they're really secretly, they've been in communication. But I need to understand what the U.S. Marshals, and if they're asking questions of her, why would she reach out to Jen? I mean, why would Jen reach out to Nicki Minaj? What's Nicki supposed to do? You know what I mean? Like, what is Nicki supposed to do about the Marshals showing up at your door? If we're supposed to believe that this is Jennifer talking to Nicki Minaj, what's Nicki supposed to do? I mean, explain that to me. So the plaintiff has misrepresented our single telephone call with each other. While I did, in fact, speak once on the telephone with the plaintiff, she has misrepresented both how the call came about and what was said during our call. So she's admitting that she spoke to Jen. Now, this is interesting. This is interesting. Now, drop in the chat and let me know. This is an interesting turn of events. Has Nicki ever admitted before that she spoke to Jen on the phone? I thought she didn't speak to Jen on the phone. I thought there was no phone call and she's denied speaking to Jen on the phone. Now we find under penalty of perjury that she's saying she spoke to Jen on the phone. Let's read that. Now, while I did in fact speak once on the telephone with the plaintiff, she has misrepresented both how the call came about and what was said during our call. My husband was arrested in March of 2020 for failing to register as a sex offender in California based upon his 1995 conviction for the attempted rape of the plaintiff. Obviously, as any wife would be, I was upset and concerned for him. Okay, now we're getting into it. I wish I had some bells and whistles because we got the exclusivity here, honey. Nicki Minaj is admitting that she spoke to Jen. Now she says, and she lets us know that it's about the rape conviction as to why she would even reach out to Jen. Now, this is interesting. A few days after arrest, Barry, an old acquaintance from the Queens neighborhood in which we grew up and known to all of us as Black, reached out to me to say that the plaintiff wanted to speak to me about what happened in 94. I did not call the plaintiff. Rather, as I recall what happened, Black connected the plaintiff and me through his phone. As any wife would do in that situation, I told her that I had been informed that she wanted to speak with me about taking back her accusation. She admits it. Now, this is tea. She admits it. Now, we know she is lying to everyone else out there and saying that she never spoke to Jen. She did not hook up with Jen through Black, but now she's admitting it. And you know why? Because Jen has proof of this, and Jen will be entering this in discovery, and Nicki wants to get out front of the story. She wants to get out front of what Jen is going to show in court. Now, for all of those that say Jennifer does not stand a chance, you sure about that? Are you sure about it? As any wife would do in that situation, I told her that I had been informed that she wanted to speak with me about taking back her accusation. This is directly what Jennifer has been saying this entire time. However, right from the start and throughout our call, I made it clear to her that I was not asking her to change her past statements. I never offered her any money, and I never threatened her. I have no doubt that the plaintiff had wanted to speak with me because she mistakenly believed that I would pay her money to take back her accusation against my husband. While the plaintiff never asked me directly for a payoff to change her story, she did so indirectly by telling me that the indictment against my husband was a big problem for him and for me. In an effort to make it unmistakably clear that I was not going to pay her money, I responded by telling her that the indictment was my husband's problem, not mine, and that he would have to live with the consequences of having chosen years ago to plead guilty to a crime which he did not commit. After I made it clear to her that I was not going to pay her any money, now she's making sure to keep saying this over and over again. And my thing is, why do you have to keep admitting, keep saying that you didn't offer to pay her any money? You should have just said that one time and been over that. You have said this over and over again. Why do you have to say that multiple times? The plaintiff told me she would think about what she wanted to do. Then, referring to her claim that my husband had raped her, she said verbatim, "I'm not saying it didn't happen, but maybe it was just a misunderstanding." I could not believe what I had just heard. I could not believe that it was so easy for this woman to imply that she may have exaggerated or lied about how much this man had suffered as a young boy in result to her accusations. Even then, though I did not pressure her in any way, I only told her that if she would like to change her statement and wanted help drafting something, my publicist, Joe Carosa, could possibly help her. Now, oh my goodness, this is T. Now, she admits to helping her change the statement and offering to have someone draft something. She is offering her publicist to help her. I gave the plaintiff my telephone number and told her that she can call me if she would like to discuss the matter with me again. I never called the plaintiff, nor did I ever want to speak to her. I spoke to her only because Black told me that she had asked to speak to me. Further, during the call, I never asked her to change her story. I never offered her any money in return for a statement, and I did not threaten her with any type of harm if she chose not to provide a statement. In fact, I emphatically told her that I did not want her to lie about anything and to tell the truth about what she had just revealed to me, only if she was comfortable with doing so. Wow. Now, do you guys see that? Now, why would you need to, if she wanted to change her statement, you would have someone help her. You're admitting. And if I was a judge, I would ask, why would anyone need to recant anything? And why would they need help changing anything? Why would they need help drafting anything? Well, why would you offer your publicist to help her draft anything? This is a direct admission. This is, as far as I'm concerned, I can see right through this. This is her getting out front of it because Jen must have some evidence. I never directed nor asked anyone to bribe, harass, or threaten the plaintiff. Other than her misrepresentation of our phone call, the plaintiff does not claim that I ever communicated with her again. Instead, she claims that I directed others to bribe, harass, and threaten her. This accusation is false. I never directed anyone to communicate with the plaintiff, let alone bribe, threaten, or harass her. And in the unlikely event that anyone engaged in that conduct, it was without my knowledge or approval. Obviously, if I had wanted to pay the plaintiff money to secure a statement from her, I would have made the offer myself during our call or thereafter, as I had her telephone number. She's admitting to having Jen's number. I thought she did not have Jen's number. I thought she didn't know how to get in contact with Jen. She's admitted throughout this brief that she has Jen's number, which is a direct admission, in my opinion, that you're able to put people in contact to directly and indirectly threaten her. Further, as discussed above, if I had been threatening the plaintiff, she would have never sent me a text message asking for help because the marshals had come to her home. More specifically, I did not direct, approve, or know about anyone supposedly offering a member of the plaintiff's family $500,000 in return for plaintiff writing a letter recanting her accusation against my husband. I did not direct, approve, or know about anyone supposedly sending Charles Misselstahl, whom I don't know, to speak to the plaintiff. Now, that could have been done through your publicist. If you said that you offered your publicist to help, maybe your publicist sent Charles. Could that be? I did not direct, approve, or know about anyone supposedly recommending the plaintiff to Ian Wallach or offering to pay his fees. Could have been done through the publicist again. I did not direct, approve, or know about Black supposedly telling the plaintiff that nothing would happen to her if she signed and notarized some papers in his possession. I did not direct, approve, or know about Black supposedly offering the plaintiff $20,000. And we know that. We know that Black offered that on his own, hoping that that would give him some clout with Nicki Minaj and Kenneth. He thought that he would be doing Kenny a favor. He thought that that would put him on the map. I don't think that it was ever insinuated that Nicki gave that $20,000 to Black. We all knew that Black did that on his own. I did not direct, approve, or know about anyone, including Black, supposedly seeking to bribe the plaintiff. I did not direct, approve, or know about Black supposedly offering to have me send happy birthday videos to the plaintiff's daughter. I did not direct, approve, or know about anyone supposedly threatening that someone would show up at the plaintiff's home if she did not sign a statement recanting her accusation. I did not direct, approve, or know about any lawyer either representing me or my husband supposedly contacting the plaintiff. I did not direct, approve, or know about anyone supposedly approaching the plaintiff's daughter, either at an Atlanta event or at any other time. I did not direct, approve, or know about the alleged August 2021 Instagram post by Black, which is discussed in the complaint. I've not lived in New York State for many years. While I grew up in Queens, New York, I have not lived in New York State for more than 10 years. I do not own any real estate property in New York State. I do not own or operate a business in New York State. I do not maintain a New York State driver's license. I do not pay New York State income tax. To the best of my recollection, with the exception of my return to New York State earlier in 2021 for approximately 2 weeks because my father had died, I have visited New York State twice in the past 2 years, approximately 3 days in May 2020 for a video shoot and approximately 2 weeks last October to host a television special. In general, I rarely visit New York State. I have lived in the state of California since 2009. Prior to that, I was a resident of the state of Georgia. As shown by Exhibit C, I pay my taxes as a California resident. And as shown by Exhibit D, she has a driver's license that is maintained in California. I declare under penalty of perjury that the foregoing is true and correct, executed on December 30th, 2021 in the state of California. So then as you look down, this is again another, goodness, she got to have so many affidavits. Now, this is her again. This is her affidavit of the process server. We read that one, and we know that basically that's her stating that they were not served by this Mr. Diaz. But like they said, we can put your ass on the stand and we can subpoena you and make you get on the stand, and we can have you raise your hand and swear, and then we can get our process server up there, and then we can see who's lying. And once it's determined that you're lying, we can have you indicted for perjury. Yes. So this is the actual tax return, 2018. It's just showing that she filed her, taxes. They blotted out her income, and that's for reasons, because they don't want to show. They don't want anyone to see her information. And that's in 2018. But actually, her income is right up here that she reported $512,200 in 2018. And then in 2019, $711,510. That's it right there. Attached federal return. I'm not sure. Is that what she has to pay? I don't know. That's the taxes that she got to pay back. I'll look that up at the, and see what this column is right here. But that's the figures. That's some figures. And, let's see. What is that column? Let me Google that real quick. Let me Google that and see what is that column. Let me see. What is that column right there? I'm going to get the information for you because, that's what a good host does. You know what I'm saying? I'm going to make sure. All right, so this is form 40 R. All right, this is column, looks like it is column 18. Okay. Oh, okay. So that's the itemized deductions, it looks like. So 512,200. So that's the amount that she's claiming. And I guess that's the amount that she would want to get back. And that maybe that's the amount that they would have to pay her back. Hmm. Hmm. Oh, so that's the year. Okay. All right. Let's see. Ah. Okay. I believe that is the adjusted gross income. Yes, I believe that that is the adjusted gross income. So, honey, they didn't blot it all out, honey, because they forgot to. That is the adjusted gross income. So in 2018, it was $512,200. In 2019, it was 711,510. And in 2020, it looks to be the same. So I believe that's the adjusted gross income. But it's worth noting that in 2019, Kenneth Petty is added to these income tax returns, as well as 2020. He's added to them. So it would appear that they are married. I mean, a lot of people were saying that she wasn't married to him. Well, they must be, because he wouldn't be on her income tax returns. So yeah, I believe that they are married. They just don't share the same last name. She didn't take his last name. She's still listed as Mirage. But if they weren't married, he wouldn't be on the tax returns. So yes, they are married. So we got the T, okay? And this is Nicki Minaj's driver's license. And honey, this is giving every bit of 2009. Child, that picture right there is giving every bit of 2009. So ever since she said she had this from 2009, I believe it, because honey, look at that. That's that old Mirage. She got that old Mirage nose, honey. This is before the BBL. This is before the BBL. The BBL is not Ellen as Miss Ellen. The BBL is not BB Ellen as Miss Ellen. This is before my nose job. I'm Nicki Minaj, you know. This is before my nose job. Honey, it's giving Mirage. It's giving your daddy name is Mirage. You got your daddy nose. Got your daddy nose. That was before the constructive surgery. Honey, the reconstructing was not constructed at that time. We still have the birth nose in this picture. Yes. Before I had my nose job, the BBL is not BBLing as Miss Ellen. They threw us down. We didn't know what to do. They took us down. We was too through. They took us down. We didn't know what to do. They took us down. We was too through. The BBL is not BLing as Miss Ellen. Shoot, this was that Mirage nose. This that Trinidadian nose. That Trinidadian nose. It's giving nose, nose, nose. Do you know anything? Do you know? Does anybody know where Nicki Minaj's nose went? Where is the nose? Do we know where her nose went? Child. Woo! Look at this. Child, this is not all natural. No, ma'am, no, ma'am, no, ma'am, no, ma'am. Pam. It is giving good. This my baby nose. This my baby nose. They took us down. We didn't know what to do. They took us down. We was tuned through. Yes, Miss Mamas, Miss Mamas. They took us down. We didn't know what to do. They took us down. We was tuned through. Yes. Miss Mamas, Miss Mamas. Child, look at that nose, honey. Ooh, that's your daddy nose. It's giving mirage. The mirages. Ooh, honey child. It's giving nose. That's a nose. Does anybody know? Do you know? I don't know. Ask my nose. Child, that was before all the anybody got it? Who got it? Who got it? Who got it? Who want it? Who want it? Who want it? Who want it? Who got it? Who got it? I need an 8-ball. Who got it? Who got it? Child, that was before that shit went up that nose and messed up that nose lining. Child, that nose is thinned out now. We have all kinds of razors to shave that nose down. Shave it down more. I got the Michael Jackson nose. They took us down. We didn't know what to do. They took us down. We was tuned through. So this has been another edition of the Sweet Pea Diaries, you guys. We have been here for 2 hours and 13 minutes. I try to get through these updates, but let's just sum it up. Lies, lies on top of lies. And I'm sorry, but these emails tell me otherwise. It's giving, really have to put all this information jam-pack into this declaration. Jen's not winning. Jen's not going to win. I can't tell. Now, we were not biased. I gave it up to Nicki Minaj and her peoples, when I didn't agree with some of the things that, Tyrone was down there doing down to the legal association. I did not agree with some of the things. And some things I agreed with, Tyrone and them. So I gave my opinion. I was honest. But at the end of the day, Nicki Minaj admits to contacting Jen. She admits to being in contact with Jen. She admits to having a phone conversation with Jen. So it's screaming lies, lies on top of lies. And she knows Jen must have something. Like I keep telling y'all, I can't wait for the discovery phase for me to see the evidence, what Jen is going to enter in as evidence. When the discovery phase comes, child, we're going to be entertained. I'm going to be on that thing. I'm going to make sure we have that information because she's trying to get in front of this. It's screaming. Sis is trying to get ahead of that information. She don't know what Jen. She's like, Jen got something. And I don't know if they've been told. I don't know if the attorneys, they know. But Nicki Minaj's attorney, they gave her that advice. I would advise that you be honest and that you go ahead and just put it out there. Put it out there before it comes out because they're going to trace these phone calls. They're going to trace these phone numbers, and they're going to be able to tell, is that Jen's number? Who contacted who? What's this text message? Who the hell is this person? Why did your publicist contact? They're going to find out all of that. So they say, get ahead of it now. So it's interesting. She's been running around here saying that she had no contact with Nicki Minaj. She had no contact with Jen. Nicki Minaj has been saying, I didn't call her. The girl don't got my number. I don't know how to contact her. And now we find out, buried, all the way in the back of the damn declaration. All the way over the back. I actually skipped over the LexisNexis information because what it is a background check. And I really didn't want to, even though the LexisNexis information is blotted out, it is not actually, this is actually a background check. So I'll scroll up there because I see someone referred to the LexisNexis information. So I'll show that really briefly, but looking at this, it was like a background check. LexisNexis is background check. It's not phone records. All right. So now this is her background check, okay? So if you look at this, this shows that. Now they got all her different names and everything, and all this stuff is blotted out. But I do see that this phone number says mobile, and it says 678. It says the phone number, and it's blotted out. No, so now I cannot tell whether or not, we do know that 678 is a Georgia area code. So we don't know if that's the number, but they'll be able to look at that. I'm pretty sure that they have the actual records and they're not blotted out. This information is blotted out because it's public data. Public people are accessing this. We're looking at it now on a live. So they blot out a lot of things. So this is not really going to show me if that is accurate because it just says 678. But like I said, they will use that document now. They're going to use this. And if that number is the same, it would show that this did come from Jen. So do we know? No, we don't know. 678, all Georgia people have 678 as an area code. We need to see what them last 4 digits do. That's what we need to see. We need to see what them last 4 digits do. So that's still, it's just not, it's not giving. No, I didn't skip over it because I knew what it was. It was a background check and there was no reason for me to go over that. And see, y'all be trying to act like I'm purposely skipping over stuff, Miss Mamas. I'm not doing that. I'm not skipping over stuff. It don't tell me anything. It doesn't tell me anything. All Georgia area codes, we got 404, we got 707. I used to live in Georgia. 678. We got 3 different area codes. It might be another one. So we don't know. We need to see those last 4 digits. If that is the case, boom, boom, that's going to bust it wide open, ain't it? Yikes. But we don't know that. You know what I'm saying? It's giving, we don't know that. We need to see them last 4 digits. All right, so Miss K. Odie, is that your name? Miss K. Odie? Odie? Miss K. Odie? Odie? Miss Mamas, we did not skip over it. It's a background check, and what approved? Where you at? What approved, Miss Kate Odie? Tell me what approved, Miss Mamas. What does that prove? I'm waiting. I'm waiting. Kate Odie. I'm waiting. They took us down. We didn't know what to do. They took us down. We was torn through. Okay, love you. Thank you for joining the live. I'm glad you're here, mamas. You had to subscribe and you had to be subscribed for an hour to be able to even comment. So the fact that you subscribed and you took a whole hour, you waited an hour to be able to subscribe and leave a comment. That shows your dedication. So I love you for that. Thank you for joining. So you guys, I love you. This has been another edition of the Sweet Pea Diaries. You guys be sure to like this video, share the video. We made it through another 2-hour live. Y'all know that I'm dedicated. Y'all know I love you. I've been working my behind off. I done posted 2 videos today and now a 2-hour live. I done edited my videos. I done did my videos. I did my videos. I did my videos, I did my editing, I did my content. I did my videos. I'm dedicated. Y'all know I'm dedicated. And that shows true dedication and loyalty to my subscribers. So now it's 138 of y'all. I need you guys to subscribe. Y'all know this was entertaining. I did the best I could. I gave y'all some tea. I gave y'all the tea. Miss Maya Rhymes, girl, this is lengthy, child. It is a lot. It's a lot to unpack, child. Yes, that was Shaq. He made an appearance. We need the videos. I did my videos. I did my content. Video. Child, if y'all know who that is, y'all, if you know, you know. If you know, you know. If you don't know, I suggest you go on over there and watch that Tasha K video, and then you know who we talking about. Video. So you guys be sure to hit that like button. Make sure you share this live. Now that's the best way to get it out there, girl. Y'all go on here and share this live. Share this live. They took us down. We didn't know what to do. They took us down. We was tuned through. With that being said, y'all have a good night. Be sure to like this video, share the video, but most importantly, be sure to subscribe to the channel, y'all. And I'll catch you on the next video. Bye.
Check the mic, make sure it sounds